Yeah, let me have a discussion in terms of the proposition of Ubuntu in Uganda today, in terms of an analysis whether we do have Ubuntu, call it Ubuntu Bulamu, call it Bulungi 1C, in that context, call it what? Gachacha, call it Harambe, call it Ujamaa, call it what you want. But the aspect of whether we have constitutional provisions within our law to be able to discuss the concept of Ubuntu, and I think that's what I'm now looking at. And I would like to take us through that dispensation in terms of a discussion of the position of Ubuntu in Uganda today. Do we have it? First of all, let me lay bare in terms of what we call the constitutional architecture. The Ubuntu Foundation, especially in light of the 1995 Constitution, does it have those grounds for us to employ Ubuntu? Obviously, I will begin by trying to create a foundational and an empirically viable analysis where I'm arguing that Ubuntu is not an extraneous philosophical input into Uganda's legal system, but is architecturally embedded in the 1990 Constitution at the very level of its structure. So the constitutional preamble, for example, its operative provisions, its national objective and directive principles of state policy, and its interpretive provisions collectively constitute what this term Ubuntu means. And by virtue of the Constitution, obviously the grand norm, Uganda's supreme law, at the structural apex, when you look at Article 1, Sub-Article 1, vests all power in the people of Uganda, not the individual citizen, not the state apparatus, but in the collective community of persons that constitute the Ugandan policy. So the collective vesting of sovereignty is a structural Ubuntu premise in terms of power, in terms of legitimacy, governance that are inherently communal rather than individual phenomenon. Number two, we look at Article 8A that was inserted by the Constitutional Amendment Act of 2005. It establishes national values and principles of governance that include unity, peace, equality, democracy, freedom, social justice, and progress. So the enumeration of unity and social justice as an operative constitutional value is a direct extension of Ubuntu's communal ontology. So unity is not the unity of uniformity, but the Ubuntu unity of persons constituted through their mutual relationships, social justice, and not the liberal distribution of principle, but the Ubuntu relational justice of a community that bears active responsibility to the welfare of all its members. And then if you look at Article 21, in terms of equality guarantee, Article 24, in terms of the dignity protection, Article 23, affirmative action, mandate in the form of Ubuntu. So it creates that when you look at Article 24, also prohibition of torture and degrading treatment, these all must be read together, the concept of Ubuntu, not merely in terms of physical integrity of the isolation area, but the relational integrity that is embedded in person. So it's important for you to understand that. But also, when you look at Article 32, it creates that positive obligation of affirmative action in terms of constitutional expression of Ubuntu, which then becomes most demanding as a moral principle. So the community becomes active in terms of the duty of care towards, a marginalized society, if you like, and that is something you understand. When you look at Article 126.2d, for example, it creates that textual cornerstone, the most textually explicit form of Ubuntu in terms of norm by the 1990 Constitution, especially Article 126.2d, which actually mandates that courts shall, subject to the law, apply the following principles: reconciliation between parties, it shall be promoted, and that provision is actually extraordinary in the common law tradition. So we are saying that there is no inherited constitutional framework that contains a reconciliation mandate, no precedent in terms of Uganda's colonial legal inheritance that is also provided for, and it was cited by the Constitutional Assembly as a deliberate constitutional innovation rooted in Uganda's own social culture traditions. So the Ubuntu tradition, in terms of Ubuntu, for example, among the Baganda, or Ubuntu among the Bachitara, or Matoput among the Acholi, in which the restoration relationship is included rather than the punishment of wrongdoing becomes primary purpose in terms of legal responses to harm. When you look at Article 126.2d, the use of the mandatory shall, rather than the permissive may, is constitutionally, decisive. In a way, courts do not have the discretion to promote reconciliation; they have an obligation. So this obligation currently discharged if, for example, all through the thin procedural expedient of mediation referrals is constitutionally grounded in Ubuntu's substantive philosophical tradition and even generates a far richer imperative in terms of requirement that actually the courts have to recognize. And that is something you must understand. When you also look at the national objectives and directive principles in terms of the Ubuntu's social architecture, the national objectives and directive principles of state policy are the Ubuntu social architecture of the 1995 Constitution. If you look at Objective 1, it mandates the common good, as the governing principle of the state, and also Objective 2, which imposes an active duty to promote the unity and welfare of all the people of Uganda. Look at Objective 24B, which requires the state to ensure that all Ugandans enjoy rights and even opportunities and access education, health services, clean water, work, decent shelter, for example, adequate clothing, food security, things like pension. Look at Objection 22. It also mandates that the cultural and customary values which are consistent with the fundamental rights and freedoms in this constitution shall actually be given expression in terms of the law. That becomes super important, again, in terms of understanding. When you look at Objective 22, it is particularly significant. It is the explicit constitutional license for Ubuntu's legal operationalization, if you like. Yeah, and therefore the Ugandan expression of Ubuntu, in light of Ubuntu, for example, or Ubuntu, or how to put, are cultural and customary values that are not repugnant to constitutional fundamental rights in terms of the framework, and that the Constitution therefore mandates them to be given expression in law. Yes, and the failure to develop this expression is not a constitutional discretion, it is a constitutional failure. We shall come to the analysis in terms of that. When you look at the enabling legislation of Ubuntu statutory president, for example, I'm going to talk about some of those components in terms of what plays out, and I would argue that Ubuntu is present, though similarly unnamed. That is something important for you to understand. So in Uganda's enabling legislation across the multiple domains, top private or even public, I'm going to try to mention some of those things. Let's look at the Judicature Act, for example, Cap 13. That becomes the primary statutory bridge between customary Ubuntu traditions and even formal adjudication. When you look at Section 15, it directs courts to apply customary law insofar as they are applicable and not repugnant to justice, equity, or even good conscience. So when you read through the Ubuntu interpretive lens, these provisions inverts the traditional interpretive hierarchy that has actually subordinated customary values to important liberal justice standards. So if Ubuntu constitutes the justice and equity, that is what Section 15 invokes, then I'm arguing that then customary Ubuntu principles are not filtered through liberal justice, but they are themselves the standard of justice by which the legal outcomes are actually assessed. Yes? So let us also understand. Look at Section 14 of the Judicature Act, which preserves the jurisdiction of local courts, for example, which operate predominantly through Ubuntu-based communal deliberation. Yes? In terms of, for example, conscience seeking, in terms of relational repair rather than adversarial adjudication. Yes? So the Local Government Act, for example, which is Cap 243, similarly institutionalizes Ubuntu-grounded community governance from village to district level, providing statutory recognition that Ubuntu institutions remain operationally viable in Uganda today. That is also very important. When you also look at other acts, like, for example, the Land Act, Cap 227, for example, the protection of customary tenure that recognizes that land that is actually held customary, it has that relation obligation between the holder and the clan or the future generation. That individual labor title cannot be accommodative in a way unless it's actually interpreted in terms of the community. When you look at Children Act, for example, the welfare principle as applied in customary context, for example, it incorporates the child's membership in terms of the relationship with the family and the clan structures as a constitutive part of their best interest. Yes? When you look at the Alternative Dispute Resolution Regulation, for example, Regulation number 10 of 2013, it institutionalizes Ubuntu in terms of reconciliation principles within the formal court system, providing a statutory basis for relational dispute resolution. It operates at Article 126(2)(d) in terms of constitutional mandate. So this idea of the ADM framework, it emphasizes on a mutual agreement and restoration relationship is Ubuntu jurisprudence enacted in a statutory form, even if it has actually not been identified by courts or even legislators. I will come to that as well. When you look at Ubuntu as an unnamed jurisprudential undercurrent, and that is something that the courts have actually played out. The most analytically significant dimension of Ubuntu's position in Uganda today is what this discussion is about. It will characterize the so-called unnamed jurisprudential undercurrent of the courts. So this examination in terms of Ugandan constitutional and even higher court jurisprudence from 1995, for example, to the present, reveals some of those consistent patterns, and I'm going to talk about them. So courts reach outcomes consonant with Ubuntu reasoning, the outcomes that even protect communal belonging, for example, rationality in terms of dignity, and the first of the integrative potential of constitutional remedies. But they arrive at those outcomes through a non-Ubuntu doctrinal apparatus, leaving the constitutional obligation of Ubuntu reasoning undischarged and the jurisprudence incoherent in terms of its foundation. That, my friend, is my problem. And that's what I want us to discuss tonight. Listen, when you act in terms of the problem of Ubuntu's jurisprudential deactivation, let's go to that. The constitution interpretive failure argues in terms of what they call the positivism grip. We have a positivism grip. The central jurisprudential problem identified in terms of this Ubuntu is argued in terms of the constitutionally present but jurisprudentially deactivated. So the mechanism of deactivation is legal positivism. The methodological in terms of inheritance, for example, of the McClory colonial epistemicides, and which trained successive generations of Ugandan lawyers and judges to treat the law as a closed textual system, unanswerable only to hierarchical superior rules or precedents, not to the philosophical traditions of the community that the law would actually desire them to govern. So the foundational statement in terms of the constitution, Ugandan constitutional interpretation, was heavily talked about by Udoma, Chief Justice Udoma, in the ruling of Uganda versus Kabatematobi. Remember that the constitution must be construed broadly and liberally. So this purposive mandate, endorsed by every subsequent Ugandan court of superior record, is systematically honored in the breach when Ubuntu values are at stake. So the broad and even liberal reading of Article 126.2d in terms of reconciliational mandate should, for example, on Mateu's own interpretative principle, generate a substantive Ubuntu theory of adjudication. Instead, the provision has actually been treated as a thin procedural reference in terms of mediation, for example. Yes, look at Attorney General versus Unifuza. The Supreme Court held that the Constitution must actually be interpreted as a whole, with each provision illuminating the others, and that purpose and spirit of the Constitution must guide its application. So the Ubuntu spirit of the Constitution, which is embedded in Article 1, Article 8A, Article 24, Article 32, Article 126.26, to D. The preamble, for example, the national objectives, has never been identified as systematically deployed as an interpretative lens that Chinefuza holistically mandates in terms of the demand. Yes, look at Paul Kawanga Semogere versus Attorney General. The Supreme Court affirmed that the preamble is an operative part of the Constitution informing the interpretation of substantive provisions. Yes, the preamble's commitment on building better future grounded, for example, in Uganda's past, is an acknowledgement of the historical struggles of Ugandan people and is an inspiration for poetry that honors their values. It provides a direct Ubuntu entry into what they call constitutional interpretation, yet the courts have never drawn this connection. That, my friend, is my problem. And that's why we're having this discussion. Let's talk about the aspect of the law in terms of the law of Ubuntu's failures as a jurisprudential audit. Let's call what they call a jurisprudential audit. When you look at a bookie, yes, the Ubuntu result without Ubuntu reasoning in Salvatore Mbuki versus Nigeria, the Constitutional Court struck down the Witchcraft Act banishment provisions as unconstitutional, holding that they violated Article 24, Article 26, Article 27, Article 29, and 44 of the 1990 Constitution. Justice Oda, in terms of concurring the opinion, reasoned that the communal belonging is constitutionally protected because the right to remain within one's home community is intrinsic to the human dignity. Yes, so the reason is actually substantively Ubuntu, in like banishment, subverts the position of the person from the web of the relationship in terms of the clan, in terms of the family, in terms of the community that constitute their personhood under the so-called Ubuntu ontology. So a person banished from their home district under the Witchcraft Act was not merely physical displacement, they were ontologically diminished, severed from the relation of fabric which Ubuntu teaches. So their very personhood subsists. The court reached the Ubuntu outcome, protection on communal belonging, but without the Ubuntu reasoning that would actually have given the outcome its deepest justification. So the trying consequence is that subsequent courts had no Ubuntu framework to build on. They had only scattered dignity, and that is something I'm making in light of that discussion tonight. We look at the Chigula case, which individualized the sentencing without relational theory. Yes, in Susan Chigula and 14 others by the Attorney General. Remember, the Supreme Court held that the mandatory death sentence was unconstitutional and required individualized sentencing. Remember, and the court reasoned that the mandatory nature of the penalty in its insensitivity to the individual circumstances of each accused violated Article 21, Article 24, and even the Constitution in light of that particular context. Yes, so when you argue in terms of Ubuntu criminal jurisprudence, it's grounded in Article 126(2)(d), which talks about reconciliation mandate and the national objective, formative justice principle. That would have actually deepened this reasoning substantially. So the Ubuntu framework would have actually required the court, for example, to ask not what are the accused individual circumstances, but what are the relational consequences of the penalty for the accused family, for example, for the community, for example, and the victim's family, for example, and how can the constitutional duty of reconciliation be discharged through the sentencing decision as a question of fact. Yes, and the relational inquiry was actually wholly absent from the court's reasoning, which borrowed international human rights frameworks rather than deploying the Ubuntu resources embedded in Uganda's constitution. That, my friend, was a super lack in terms of that dispensation. So the companion case of Jackson Mutware versus Uganda, for example, represents a modest advance. The Court of Appeal invocation of reformative justice as a sentencing principle gestured towards the Ubuntu reintegration principle, yes, but reformative justice in the court's usage was a borrowed rehabilitative psychology framework rather than an Ubuntu relational theory grounded in the constitutional mandate as provided for under Article 126(2)(d). So the gap between what constitution requires and what the courts deliver still, my friend, remains. That's what I'm making, sounding this as a drum major for that. When you look at Mufumi, for example, in terms of Ubuntu values that are assessed through what? Non-Ubuntu standards. Look at Mufumi in terms of litigation, spanning both Constitutional Court in 2010, but also in terms of the Supreme Court in terms of 2015. It is the most sustained Ugandan judicial engagement with a custom that is directly Ubuntu in its own social function. Bride price, for example, the so-called Umutwaro, was a communal acknowledgement of marriage, in terms of relationship. So the mechanism by which these two families and through them two communities formalize their relational bond is not a commercial transaction for the purchase of a person. It is an Ubuntu ceremony of community recognition, and that is something you must understand in light of this dispensation. When you look at the courts that assess the bride price exclusively through the liberal rights framework, look at Article 21. We are asking the question, asking whether the custom treats women as individuals in terms of equality with men without engaging with the internal Ubuntu normative of logic of the practice. So the Ubuntu question was therefore whether the custom promotes relational dignity, community responsibility, and the mutual recognition of the families involved. Was it entirely foreclosed by the imported liberal framework or methodological error in terms of precisely what is what we're trying to underscore here? So Ubuntu values are actually treated as a potential limitation on individual rights rather than independent constitutional values with their own normative logic and their own constitutional standing under Objective 22. And that's extremely important for us to understand. Look at the FIDA case, the equality without rationality. The FIDA Uganda versus Attorney General. The court's gender equality analysis engaged with customary social engagement, but assessed them entirely through Article 21, equality in terms of a framework. So Ubuntu's alternative approach in terms of accessing customary practices by reference to their capacity to promote relational dignity in terms of mutual responsibility, in terms of reintegration of marginalized members was absent, and the court's treatment of Ubuntu hype, this type of communal values as a potential litigation on individual rights rather than the independence of constitutional values is the structured jurisprudential error that reoccurs across our case law, even as we stand today. And that, my friend, is super important for us to understand. Look at Kanyamunyu in terms of a case, the Ubuntu discretion without Ubuntu doctrine. Yes, in Kanyamunyu and another versus Attorney General, the High Court invoked the accused family relationships in terms of community ties, the Mataputo courses that were carried out, the social integration of constitutionally relevant factors in terms of bail determination, for example. And this is structurally Ubuntu reasoning, yes? But the court assessed the accused relational personhood, yes? His embodiness in a web of communal relationship that both gave his liberty, social meaning, and also imposed social accountability on its exercise. And that is important for you to understand in terms of how Ubuntu now plays out in some of these cases. But the Ubuntu vocabulary was entirely absent. That's a problem. It was entirely absent. The reasoning was anchored in unexplained judicial discretion, a feel of relational dimensions of the case, rather than in the constitutional obligation as imposed by Article 126(2)(d). And the Ubuntu values embedded in the national objectives And therefore, the consequences is that the Ubuntu reasoning in Kanyamunyu cannot be built on by subsequent courts. It cannot be cited as authority for an Ubuntu-based approach into Bay, for example, because it does not identify itself as such. Yes, so it is Ubuntu reasoning that has no jurisprudential future. That's the point I'm making, my friends, and that is my challenge in terms of this dispensation. Listen, when you talk about the statutory failures in terms of the penal code, and for example, in terms of Witchcraft Act or even the anti-Ubuntu law, you know, if you like, I'm now making that blanket sweep. The most direct site of tension between colonial positivist law and Ubuntu jurisprudence in Uganda at statutory level is the Penal Code Act, which is Cap 120. So the code's mandatory sentencing framework, for example, in terms of capital offences, partially dismantled by Chikula, but still operative in many provisions, is the statutory embodiment of anti-Ubuntu punishment theory. Yes, so it forecloses the rational, reintegrative analysis of the accused communal embeddedness that Ubuntu criminal jurisprudence demands, that Article 126(2)d constitutionally requires that particular, mandate, if you like. So, for example, if you argue in terms of Witchcraft Act, which is Cap 124, whose banishment provision will actually structured in Abuki, it represents the colonial legal system's most direct assault on Ubuntu's foundational principle in terms of communal belonging. So, the act survived in Uganda's statute books until constitutional challenge was required to remove its most egregious provisions as a measure through which the depth of colonial positivism in terms of inheritance, and that is what I'm trying to seek to dismantle here. Look at the Succession Act, Cap 162. The formal inheritance law framework similarly failed to accommodate the Ubuntu principle that property passes through a web of communal obligations rather than merely through a testamentary will. Yes? So the tension, my friends, between the Act's individual succession model and the communal inheritance practices of Ugandan communities, including the clan-based arrangements that the Supreme Court engaged with, for example, in Sebalu versus Genda, is a persistent site in terms of Ubuntu's judicial suppression. And that is something you must understand again in terms of our dispensation tonight. When you look at the other thing, then what is the problem? What is wrong with, for example, the literature that we have so far come across in terms of the Ubuntu? The gap in Ugandan constitutional scholarship, if you like, is the most consequential failure in terms of the existing failure to develop specifically Ugandan Ubuntu jurisprudence. When you look at Kabumba's constitutional law scholarship, it represents perhaps one of the most significant Ugandan contributions in terms of this field. His identification of Ubuntu, in terms of Ubuntu, for example, as embedded but unactivated by the 1990 Constitution, and his characterization of its absence from constitutional jurisprudence is a curious and consequential lacuna. Yes, and are the strongest statements in terms of Ugandan academic literature of the problem that I'm trying to address tonight. And that is something you must understand, again, my fellow listeners. Listen, yet even Kabumba's work, which is basically acknowledged that its immediate scholarly predecessor does not develop the doctrinal bridge from Ubuntu philosophy to constitutional adjudication. In fact, his decolonization scholarship identifies the educational system as a primary mechanism of Ubuntu jurisprudential suppression, but does not produce the doctrinal tools, the interpretive principles, the constitutional standards, the remedy frameworks that we're looking for. That would allow Ugandan courts, for example, to operationalize Ubuntu without waiting for educational reform in terms of working through the system. That is something that I'm discussing for you tonight. When you look at the broader Ugandan Legal Academy, we're arguing in terms of the negligible exceptions, produced no sustained scholarly work on Ubuntu jurisprudence. The dominant approach treats the positive common law framework as the settled and adequate methodology for Ugandan constitutional interpretation, and Ubuntu, to the extent it appears at all, is treated as a subject of customary law courses rather than a constitutional law scholarship. And therefore, this is something I'm also trying to argue in terms of this academic context, in terms of as a pioneering work in terms of the dispensation of Ubuntu in our country today. When you argue in terms of the moral philosophy gap, where we argue in terms of theory without doctrine, the international Ubuntu literature, look at Ramos's ontological grounding, look at Mays' analytical moral theory, look at Mbiti's relational philosophy. It is philosophically valuable, but jurisprudentially insufficient for Uganda needs. Yes, Mays' demonstration that Ubuntu can withstand analytical philosophical scrutiny and also generate specific moral obligations, and that becomes very important as a groundwork for our country. But the gap between the moral philosophy and constitutional doctrine is not automatically bridged by analytical rigor. And that is something, again, we have to understand. So constitutional doctrine, for example, requires that philosophical principles are actually translated into interpretative standards, institutional procedures, and even remedial frameworks that are usable by courts in terms of operating within the constraint of judicial institutional capacity, precedent, and even procedural law. So I'm arguing, my friends, that the methodological translation in terms of from Ubuntu philosophy to Ugandan constitutional doctrine is the primary intellectual task for this discussion tonight, and it is a task in terms of the existing literature that has not undertaken, unfortunately, for the specific constitutional context that would like it to fall under. When you argue in terms of the challenges that were proposed by Professor Mamdan is warning in terms of the colonial distortion of customary law. In fact, also Ali Marizuri also makes a very important aspect, and also Professor Romase also. But let me argue this: the existing literature in terms of the customary law and Ubuntu in Uganda must actually be read in terms of Mamdan's warning. Yes, firmly in the view that colonial administrators did not simply ignore African customary law; they actually codified and instrumentalized it, transforming flexible communal Ubuntu norms into rigid hierarchical structures that actually serve indirect rule rather than philosophical values of communities from which they were actually derived. And that is something we're arguing that is a big problem tonight. Now listen, the customary law also recorded in terms of the colonial era, in terms of Ugandan legal text, including the materials relied upon by Mufumi and other customary law cases, is therefore not an authentic repository for Uganda's values, but a colonial distortion. Yeah. So any Ubuntu legal recovery project must actually engage with living Ubuntu traditions as they understood and practiced by their cultures. Talk about the Baganda. You know, the aspect of the Ubuntu traditions of Western Uganda, for example, the Mataput practices of the Acholi, for example. The argument here is that the living tradition, not its colonial codification, yes, is authentic Ubuntu source. That is what I'm making a case for. And when you argue in terms of Sesanti makes a very wonderful dispensation in terms of the colonial challenge, institutionalization, and or irrelevancy. In fact, Sesanti's article in 2025 contributes in terms of the sharpest challenge to inadequate Ubuntu scholarship. Ubuntu's decolonial potential is only realizable. It is institutionally embedded, not merely rhetorical in the form of structures of the law and even governance. So Ubuntu is invoked as a cultural supplement, a vague aspiration or a motivational philosophy for communal harmony, not Ubuntu jurisprudence. And it is Ubuntu domesticated, but the very colonial epistemology it seeks to displace. That is what Professor Ramasa called epistemalization of our laws. You know, so it applied in terms of the Uganda situation. Senanti challenges us that Ubuntu legal scholarship fails to produce concrete doctrinal tools for institutional deployment as an adequate aspect in terms of this. So Ubuntu's interpretative principle in terms of this would propose designs precisely to answer this challenge. It is not a philosophical gesture towards Ubuntu, but a doctrinal framework for its systematic institutional deployment through Uganda's existing constitutional and even statutory architecture, if you like. Now, I'll also make a discussion in terms of the solution. If we are having this problem, then where are the solutions? What are the solutions in terms of the Ubuntu interpretative principle and the new dispensation? I'm arguing and making a case that the theoretical synthesis would argue in terms of what Dawkins is a philosophy in terms of transformative constitutionalism, and JK also the theoretical framework in terms of the synthesizes these elements into what they call an integrated jurisprudential approach applicable to Uganda's constitutional context. So the first element is Dawkinian, from that gentleman called Doke. So and it's argued in terms of interpretatism. Yeah, Dawkins' principle of the law as integrity holds that constitutional education that requires identification of the principles that best fit and justifies the legal materials in terms of constitutional text, in terms of the preamble, in terms of the national objectives, in terms of precedents, and in terms of a coherent whole. So the application, in terms of the application of the entire constitution, we're arguing that the weekend question there becomes a question of importance. Which principle most coherently explains and justifies the full assemble of constitutional provisions in terms of Article 1, 8A, 21, 24, 32, 126, 2D, in terms of the preamble, in terms of the national objectives, in terms of all those elements? Can we argue these provisions? So my point is that the answer is we should express these aspects of Ubuntu in the principle that renders the 1990 Constitution most coherent as a moral and political document. And the second element in terms of transformative constitutionalism, in terms of Clary's framework, I'm arguing that the post-colonial constitution must actually be interpreted as inspirational charters requiring active judicial engagement, directly applying to Uganda's 19th Constitution. And the Ugandan Constitution ideally was actually designed to overcome the inherent injustices of colonial legal architecture. So the transformative interpretation requires, therefore, the courts to read constitutional provisions in light of the transformative aspirations, which in Uganda's case includes the aspiration to recover and operationalize the Ubuntu philosophical tradition that colonial positivism does actually suppress. And then the third element, in terms of Jeche's restricted communitarianism, would provide the philosophical anchor that prevents Ubuntu's constitutional application from actually collapsing into collectivism. Yes, so Ubuntu is not the subordination of the individual to the collective. It is the philosophical recognition that the person are constituted through communal relationships and bear obligations through their communities. So it is also important to know that while retaining that irreducible individuality that the community cannot dissolve, the argument is that this balance in terms of rational personhood without collectivism, subordination, is precisely the balance the 1995 Constitution achieves in its very structure. So individual rights as provided in Chapter 4, for example, within the command of constitutional architecture in terms of the natural objectives. You look at Article 1, you look at Article 8A, Article 126, 2D, and in terms of that component. Then the point now that comes to mind is the Ubuntu interpretative principle as a doctrinal framework. Yes, Ubuntu becomes, we could argue it as Ubuntu interpretative principle is a centerpiece, for this discussion in terms of a contribution to Uganda's constitutional law. It will hold that constitutional provisions usually are read or even applied in the light of their relational purpose. Yes, the protection and promotion of person as embedded within their communities, and the restoration of relationships, fractured by wrongdoing, and the recognition that communal solidarity is actually constitutional value with independent legal force, as mandated by Article 1, Article 8A, Article 24, Article 32, Article 126(2)(d). And the objectives 1, objective 2, objective 24 and 22, and Article 274 of the 1995 Constitution. That is extremely important for us to comprehend. In terms of the interpretative obligation, at the first level, we could argue that it will generate an interpretative obligation where constitutional provisions are capable of two interpretations. One consistent with Ubuntu relational values and the other not. So the Ubuntu consistent interpretation must actually be preferred. This is not a novel interpretative methodology, no. It applies the standards of constitutional principle affirmed in the cases of Tinyefunza, that provision must be read in the light of constitutional fundamental values. Yes, and therefore it insists that Ubuntu is among those fundamental values. It is manifestly given by Article 126(2)(d) in terms of expressing reconciliation, mandate, and even Objective 22 in terms of command and the cultural values that have to be given by the expression of the law. That is extremely important. Then if you argue in terms of the domain of a specific constitutional standards, at the second level, we could argue that it should actually generate domain-specific constitutional standards in terms of criminal sentencing, for example. When you follow the deepening cases of Chigula and then Mutwale, then we could argue that this requires courts to consider not only the accused individual circumstances, but the relational consequences of the sentence. It is impact on the accused family and the community, on the victim's family, and the capacity of the court to discharge it, and under Article 126(2)(d) of the obligation of promoting reconciliation. So the aspect of mandatory sentencing provisions in the penal code that foreclose this relational inquiry must actually be read. You look at Article 2274 as modified to require relational consideration wherever possible. That is extremely important. Take, for example, in terms of customary law dispute that follow, even correcting in terms of the Mufumi case, we are saying that the customary practices be accessed through Ubuntu lenses of the Objective 22. Does the practice promote, for example, rational dignity, communal responsibility, and the Ubuntu values of the community that it practices? Is it not an critical endorsement of all customary practices? Is it an insistence that customary practices must actually be assessed by their own Ubuntu terms rather than exclusively through imported liberal right frameworks? Before constitutional equality standards in terms of Article 21 is applied to override some of them, and that is something you must understand. So in terms of property and even land disputes, when you're building on cases like Sebalu versus Uganda and the Land Act's customary tenure provision, we are saying that it requires the rational obligations attached to customary landholding obligations, to family, to clan, to future generations, that must be given constitutional weight in terms of expressing of the Ubuntu values embedded in the constitutional communal aspect, if you like. And then we argue in terms of the third level, which we are arguing in terms of the relational remedies, we could say that this should be able to generate an Ubuntu theory in terms of constitutional remedies, following the principles as embedded in Article 126(2)(d), where the constitutional violation has actually fractured communal relationship as the case of wrongful banishment, for example, in Abuki, or mandatory sentences in terms of Chigula, or discretionary exclusion. The constitutional remedy must prioritize relational repair. So this means that the declaratory reliefs or even apology orders, community reintegration programs, and even restorative justice processes must actually be considered alongside and in an appropriate case referred to in terms of compensatory damages that vindicate the individual right while leaving the relational harm and repair. You must understand that again in terms of this discussion. When you argue in terms of the constitutional basis, we are saying no amendment may actually be required in terms of it, but there are some substantive decisions we have to take. The constitutionally, the decisive feature of this particular concept is that it requires no constitutional mandate. The declaring foundation is actually already present in our 1995 Constitution as enacted by Article 162D in terms of the constitutional mandate, in terms of textual cornerstones. But that's the point. So we argue in terms of Article 274. Its instructions to read existing law in conformity with the Constitution is interpreted as an engine. So Objective 22 commands that the culture and community customary values be given expressions in law that is explicit in terms of authorization. Article 8A in terms of national values provision, Article 1, Article 24, Article 32, relational dignity, equality, affirmative action in terms of substantive action. This should be the case, And so what we are saying is that it requires not an amendment but activation. The interpretative will to name the Ubuntu that is already present in the constitutional architecture is to build from the recognition of a systematic doctrine. The constitutional mandate is already there. Look at Matovu. Matovu's broad and liberal reading in terms of Ginefunza as well. It gives us that holistic constitutional interpretation in terms of Semogere's operative preamble, for example. But what has been missing is the philosophical framework that reveals the Ubuntu values, these interpretative principles properly applied. That is the biggest challenge that we're having. When you look at the Mabirizi resource in terms of constitutional protection, yes, of the Ubuntu architecture, the Supreme Court recognition in the case of Male Mabirizi, Chiwanuka versus Attorney General, as a doctrine of unconstitutional constitutional amendment provides an additional constitutional resource for the protection of Ubuntu constitutional status. If the Ubuntu architecture, for example, of the 1995 Constitution, in terms of its relational dignity, is a communal sovereignty, its reconciliation mandate and culture varies in terms of provisions, it would constitute a dimension of constitutional basic structure. Then, in a constitutional amendment designed to fundamentally dismantle the architecture could actually be challenged on the basis of unconstitutional, on the basis of the structure grounds. Yes? So that's, again, important for us to understand. It is not merely a defensive constitutional resource. No, it becomes a positive one. It means that the Ubuntu architecture of the 1995 Constitution is not merely a current interpretive resource, but a constitutionally entrenched feature of Uganda's supreme law, protected by the basic structure analysis, even against constitutional amendments. You can imagine. So the point here is therefore not to merely look at it as a tool for statutory and case-by-case interpretation. It is an articulation of the constitutionality entrenched value that the Constitution itself protects from it being dismantled. And that is what I'm making in terms of this case. What then occurs in terms of the new constitutional dispensation? We could argue that the new constitutional dispensation, therefore, is not a rupture within the 1995 Constitution, but its fulfillment. So we're arguing that Ugandan courts already have in their hands the constitutional architecture text, the preamble, yes, the national objectives, yes, the interpretive provisions, yes, but these needed to generate a rigorous Ubuntu jurisprudence. But what they lack is the interpretative framework that reveals the architecture of Ubuntu's character and provides doctrinal tool for its systematic deployment. So we are saying that Uganda, as of today, should apply, yes, in light of Article 126.2d, in terms of reconciliation, in terms of the mandate to generate binding constitutional obligations, rather than procedural suggestions which, for example, criminal sentencing decisions in terms of cases like Chigula's work are actually systematically, assessed for their rational and even reintegrative consequences, in which customary practices, for example, in the cases of Mifumi, domain are actually assessed in terms of their Ubuntu terms before even Article 21, equally standards in terms of the apply. So we are saying in which the dignity guarantees of Article 24, for example, is read as the dignity of the relationality embedded in the person rather than the atomistic liberal individualism of individual aspects in which the judicature acts customary law provisions are actually read mandating Ubuntu justice rather than filtering customary values through liberal justice standards. And that is what I'm saying. So above all, it would be very, very important that the courts finally honor the full contextual constitutional text, yes, not the pound of flesh positivism formalism, where the spirit of rational humanity that the 1995 constitution embeds in its architecture, and that the Ugandan people have actually lived in their traditions of Ubuntu, or Ubuntu Bulamukolito, or Matoput, for generations beyond they reach any written constitution. That, my friend, becomes the most important aspects in terms of this dispensation that I provided tonight. So, in terms of a takeaway, what then would be in terms of the takeaway for these three propositions in terms of my argument tonight? I'm saying, in terms of the proposition of Ubuntu in the 1995 Constitution, the 1995 Constitution is actually built on Ubuntu. You look at Article 1, communal sovereignty, Article 8A, national values, Article 24, relational dignity, Article 32, positive duty of communal care, Article 126.2d, reconciliation mandate, objectives 1, 2, and 24, and even 22. The 6th schedule recognition of what? Traditional institutions, Article 274, transformative interpretation mandate. These read together through the so-called Draconian interpretive and even Tenefuza's holistic constitutional reading constitute a comprehensive Ubuntu constitutional architecture that requires only interpretative activation, not constitutional amendments. Remember that in terms of my dispensation. In terms of the proposition 2, you would argue in terms of the positivism deactivation of the Ubuntu architecture, the colonial positive legacy methodology installed by people like McLaughlin, epistemic, in terms of the perpetuated wrong of the Ugandan education and the judicial culture, is structurally mechanism through which the Ubuntu architecture of the 1995 Constitution is systematically deactivated. So the case law in terms of Abuki, to Chigula, to Mufumi, to FIDA, to Kanyamunyu, demonstrate the consistent pattern in terms of Ubuntu consent outcomes reached through these non-Ubuntu reasoning, generating what we call jurisprudence that cannot be built upon because it does not identify its own philosophical foundations. So we are arguing that the existing Ugandan scholarship, including Kabumba's foundational contribution, has actually identified but not bridged the gap of Ubuntu philosophy and constitutional doctrine. That, my friend, is extremely important. When you look at Proposition 3 in terms of the Ubuntu interpretative principle, yes, it activates what the Constitution already contains. So the Ubuntu interpretative principle, grounded in Dukinian interpretatism, operates through transformative constitutionalism, anchored in JH's restricted communitarism, and also by Article 126.2d, Article 274, and Objective 22 of the 1990 Constitution. They provide for, in terms of the doctrinal bridge between Ubuntu philosophy and constitutional adjudication. So its deployment, therefore, requires no constitutional amendment. It requires only interpretative will already mandated by the Constitution itself through the Matovi's broad and even liberal reading of Tinyimfuza holistic interpretation, to name and other Ubuntu that's already present in Uganda, but to build from that recognition. The new constitutional dispensation of the 1995 Constitution has always been demanded, and that's perhaps what, my friends, we need to look out for. Once again, I thank you for your attention. We shall continue with the next discussion in terms of demystifying what Ubuntu is, what it is not, and how it should be played out in our jurisprudence today. Thank you. God bless you.